Колеги, продовжуємо наш робочий день. Зараз
Continue our working day now. Will be our colleagues, judges, will be talking about the strategy of development of Ukraine's judiciary for 2015-2020. I would like to invite Anatoliy Martsynkvych, Secretary of the Council of Judges of Ukraine, judge at the Khmelnytskyi region, Court of Appeals, Tetiana Chumachenko, member of the Council of Judges of Ukraine, Bohdan Monich, member of the Council of Judges of Ukraine, head of the Budget Committee, Grygoriy Aleynikov, member of the Council of Judges of Ukraine, Committee on Administering, and Yulia Zemlinska, who's a specialist on legal issues of the EU project support to justice sector reforms in Ukraine. Good afternoon, ladies and gentlemen. I'm Zemlinska Yulia. I represent the EU project support for justice sector reforms in Ukraine. As the experience of European countries certifies, only part of the success of judicial reform depends on the changes in legislation. Another is the issue of change of behavior and practice of legislation implementation. And the judges play here a very important role when in June 2014, the Congress of Judges of Ukraine delegated to the judges to develop and pass the strategy for Ukraine's judiciary for 2015-2020. Our project has supported this initiative, and we were providing the consultations to the Council of Judges all the time. The process of drafting the document was very lengthy. A working group was set up, which included the representatives of judicial institutions, of advocacy, prosecutor's office, and civil society. The document that we present is not just a corporate project of the judiciary system. It takes into account the views from a side. Why this document is so unique? The strategy for the development of judiciary defines the objectives and priorities for the development of the judiciary for the next 5 years. That's restoration of the trust, the enhancing the level of professional training, enhancing the efficiency of judiciary. But what is also important, it specifies the specific actions and measures to achieve these objectives. Specific KPIs are identified. There's a specific time frame. This is the action plan for the next 5 years for the judiciary. And what is also important is that this document provides for actions which could be taken by judges independently within their competences. The judges do not depend on the changes of legislation which take place all the time. They can do something independently. Why the document is so important, and why it is so important that it is adopted right now. We believe that the strategy of development of judiciary gives two important signals to the society. First, that the judges understand the problems, understand how serious the problems are, and they are not happy with the status quo in the judiciary. Second, the judges are ready to change and to take specific commitments as to implementing certain things, and the strategy certifies to that. And the project of EU very positively treats this document, and we believe that implementation of this document will bring the European system closer to Ukrainian system closer to European standards.
Good morning. Judge Chumachenko Tetiana, a member of the Council of Judges of Ukraine. Our state recently goes through many difficulties, and we overcome big challenges. And the right for fair trial, that's a constitutional right of a person. Ukrainian society demands efficient, accessible, transparent judiciary. Such efforts, such aspirations require changes in the judiciary and the reforms. On the state must provide to its citizens the efficient and fair trial. And judges are waiting also for those reforms. Representatives of the judiciary and all judges of Ukraine are ready to participate in the discussion of the ways how to reform the judiciary. To achieve those goals, that means that it requires a lot of work, and that depends on judges. And that's why we have this strategy of the development of the judiciary for 2015-2017. And we make the presentation of that. The document has the power of voluntary. We need to change the system of judiciary to improve the services for the and to bring our judiciary to the best, closer to the best European standards. The strategy means planning for the future, long-term development of the judiciary, and it includes how to improve the situation in the judiciary. Our strategy has agreed actions to rebuild trust to judiciary, independence of judges, the improvement of efficiency, better use of resources, and development of better communication, and improvement of professional level of judges. We hope that realization of all components of the strategy and improvement of this situation in the judiciary, and that's the most important, the most ambitious plan. And I hope also that in this process, the judiciary will be supported by the legislative power, and we'll have very good cooperation. But the judicial reform, that's a task for all state bodies. The strategy that we present for 2015-2017, that is just one of the steps in the reformation of the judiciary, comprehensive reformation, and also reformation of the justice system in general. Thank you for your attention. Good morning, Bohdan Monich, the head of the budget committee of the Council of Judges of Ukraine. And if I continue what my colleagues talked, I will speak about the direction I'm responsible for. The judiciary for years is underfinanced, and everybody knows about that. Having passed this strategy, developed this strategy, what are our goals? First of all, how to improve the financial support for the judiciary, but also how to improve the efficiency of of that money that we get from the budget. Believe me, that work has begun, and there are a lot of directions, a lot of programs on which judges, and we see where through better use of the budget, limited budget or in our country, that there are ways how to improve the efficiency of using that money. So we will work in that direction, and our goal is how to improve expenditures of courts and the services our courts provided to citizens, for how to make them efficient for us, and not to have problems with the paper, with the postmarks, with the envelopes. People, when they come to the court, they receive good quality services, and we will work on that. Thank you. Grygoriy. Good morning, dear ladies and gentlemen. I'm Aleynikov Grygoriy, head of the Committee of the Council of Judges of Ukraine on administration. Those issues that we worked on in our committee, that's the most important, is the introduction of e-court. What does it mean? E-court, it's when, in the end, we can consider cases and move them from one to the other instance electronically. That's a huge step forward, and we saw that our neighbors in Moldova, they introduced that in cooperation with Americans. They introduced that approach, and it's very efficient. Its efficiency means that we reduce the time for documents flow. As soon as someone comes to the court and submit an application, or a prosecutor sends materials then those materials are documented and sent to automatic distribution, and then judges receive and they decide on cases. What does it give? In addition to the case in electronic database, it allows the society to control cases, every case in a court, and that's very important. Also, we are planning to install in courts automatic devices for people who could pay court fees and to receive a copy of court decisions when they need. When there is a special agreement with courts, then legal or physical entities can, when a judge brings a case inserts it into electronic form, can receive a copy in his office or home through any device that can connect to internet. That's a very important step, and judges understand the high responsibility that when they take that, when we take that obligation to introduce e-court, that on the same day when they consider a case, they give a decision. It is documented, signed by electronically, and the access. Everybody has an access to that decision. To implement that, we have several e-courts in Venice Administrative and Appeal Court. They developed the software. They developed software, and in their court, electronic court works from A to Z. Access to court means that people would like to be present when the cases are considered. It's not a secret that we have a budget, and we cannot. It's very difficult to provide the access to the courtroom to people.
But I believe that the state understands the necessity of allocating money for that in order to ensure that the citizens could be present in the room of court proceedings during any court proceeding. I would like to thank the European community for finding money and experts who helped us draft this document, and I am sure that they will help us in implementation of the document. Addressing you, I would like to say that your role as people who covered these events in Ukraine so that our strategy becomes a success is very important. We would like you to demonstrate to Ukrainian citizens that the judges themselves want to work more efficiently. They want to put more efforts into their work so that the citizens receive high-quality services in courts, and we address the journalists. We are open for journalists, for our citizens, and you can see that we now organize open meetings of the Council of Judges, and that is done to show the society that the judges are ready to cooperate, to work efficiently, to defend the human rights and freedoms. Thank you. Good afternoon, ladies and gentlemen. I am the Secretary of the Council of Judges. My colleagues have told you about our plan, our strategy of the development of judiciary system. Today you see that the judiciary system is not stagnant. The judges are working themselves and they think about how to improve the work of the judges and courts. I would like to mention some of the things. You see that the strategy envisages short-term, medium-term, and long-term stages. We have already done something. We have seen that, well, unfortunately, we were taught so that we have to express our ideas only in the resolutions of the courts, but not to communicate to journalists, and that is why the judiciary system has lost a lot, and we have set up this Council of Judges. In the Council of Judges, we now have a press secretary, but unfortunately the monitoring of the work of all these press secretaries demonstrates that they work not very perfect, and I believe thanks to you journalists, thanks to our press center, we will be creating a better image of our system, a real image of the courts. The issue of assessing the activities of judges, you know, there are many surveys made, and the results of the surveys show that the people trust the judicial system, and some other time they show that they do not trust. But all the international organizations say that we do not have the system of assessing the work of the judges and the court. So what our colleagues have been developed, we would like to develop more this system, including the surveys, the statistical data, so that we can see how the courts are operating now. The issue of professionalism. We hope and we are grateful that we want our judges to receive good services, to receive good training. The School of Judges has to train the candidates for the position of judges. Now they are trained for 6 months, but a year is required. They are now also developing the curricula for training of judges, and that is what we want to do. It's working. I cannot say that it doesn't work, but there's room to improve the professionalism of the judges via such training. And what we have done and what we want to do, it's all in the strategy, in the plan. And that's the document which provides for very specific objectives, and we have done something already. If you have any questions, we'll be happy to answer them.
Where can we get that information, the strategy? On the website of the Council of Judges, and that's there. Everybody can go to that website, and we have some copies with us, so if you want to, you can get them. Colleagues, your questions to the speakers. In the frame of this, during this reform, the important question is execution of court decisions. What's your attitude to the Institute of Private Executor or Implementers? That's a very complicated issue, because European practice decisions, a case is considered if a court decision is implemented. That's what the European Court of Human Rights says. We have lots of cases that are not implemented, and that a judge had earlier. A judge had an executor, an implementer, and it worked better, and there was a court control over the implementation of court decisions. So there are different views, and maybe we should introduce an administration, court administration, or maybe an institute of private implementers. I don't know how we envision that, but the way we have it now, we cannot continue like that. It's it's awfully difficult for the society, and these decisions are not implemented, and that's something very negative for our system, court system. No question. Everything is clear. Thank you very much, colleagues. You can leave your copies of the concept of the strategy on the front desk. Our next briefing will be at 12 o'clock, and there will be an advisor to the Prime Minister of Ukraine, Danilo Lubkivsky.